going to be covering that in this video. Probably going to be super boring. You can go to my Twitter, which is Vote Lambright. I actually tried to go to sleep, but I couldn't sleep. And I kind of just want to rub it in everybody's face that as a society, we're broken. There's no real law enforcement. These pedophiles are running the world, and your local police won't do shit about it, okay? They'll arrest a working class pedophile, but they won't arrest a rich person. And that's who we are as a country. We're pathetic. If you don't know who I am, my name is Wayne Lambright. I ran for president 3 terms, 2016, 20, and 24, and I'm running in 2028. And I'm independent, and I'm doing a scorched earth, leave no prisoners behind, the rawest truth that I can find for you. I'm not here to impress you. I'm here to rock the boat, and everybody's going to get wet. If we keep doing what we've been doing, we're going to keep getting what we've been getting, which are pedophiles running our country. 800,000 children go missing every year. I think that's 16,000 children per state. And I think it's 15 kids a day go missing. Okay. So I use Grok to pull up the court documents. Here are the court documents. Thanks, Charles. I'm going to try my best to read all 19 pages. It shouldn't be too hard. It's only 19 pages. Might take us a half hour. I might stop and talk about it a little bit here. I got some flies. I got a fly problem right now. I'm half sleepy. I wish I had some beers. But luckily, my ADHD is always here to keep me entertained, doing 3 things at the same time. Oh, let me show you a picture of what she looks like. I showed it at the beginning, but that's the girl. And there she is giving testimony as an adult. And I've listened to it. Her name is Katie Johnson. Whew. In the United States District Court, Southern District of New York, Jane Doe proceedings under the pseudonym plaintiff versus Donald Trump and Jeffrey Epstein. Jury trial demanded. Complaint for rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and defamation. Plaintiff Jane Doe proceedings under the pseudonym bringing this action against Donald J. Trump and Jeffrey Epstein and alleges that parties, 1, plaintiff is an individual residing in and a citizen of the state of California. 2, upon information and belief, defendants Donald J. Trump and Jeffrey E. Epstein each reside in the district and are citizens of the state of New York. Judicial and venue. Plaintiff is citizen of the state of California for purposes of diversity jurisdiction under 28 U.S. Civil Code 1332. Defendants are citizens of the state of New York for the purpose of diversity jurisdiction under 28 U.S.C. 1332. The court has original subject matter jurisdiction with respect to this action pursuant 28 U.S.C. 1332, as there exists complete diversity of citizenship between plaintiff and defendant, and the amount in controversy exceeds $75,000 exclusive of interest and costs. Defendants are each subject to jurisdiction of this court pursuant to 28 U.S.C. 1332 with proper venue pursuant to 28 U.S.C. 1391, as both defendants are residences of and/or domicile in the district, and the events giving rise to the claim occurred in this district. Rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, and false imprisonment. Plaintiff was subject to acts of rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and threats of death and/or serious bodily injury by the defendants that took place at several parties during the summer months of 1994. Which is 31 years ago. Parties were held by defendants Epstein at the New York City residence that was being used by defendant Epstein at 9 East 71st Street in Manhattan. During this period, by the way, I should be using glasses, but I don't have functional glasses, so that's why I'm squinting. During this period, plaintiff was a minor of age 13 and was legally incapable under New York law of consenting to sexual intercourse and the other sexual acts detailed herein. New York Penal L 130.053A. The rape is the first, second, and third degree, sexual misconduct, criminal sexual acts in the first, second, and third degrees, sexual abuse in the first, second, and third degree, and forcible touching and on information and belief, predatory sexual assault detailed herein, and unlawful under New York law, e.g. New York Penal L 130.20-130.52 and 130.55-130.65, and on information and belief 130.95, and constitutes the tort of inter alia, assault, battery, false imprisonment, and intentional or reckless infliction of emotional distress, including threats of force and serious bodily harm under New York law. In addition, 18 U.S. Code 2255 provides plaintiff with a civil remedy for personal injury because plaintiff was a minor, was a victim of violation 18 U.S.C. 1591, 2421, 2422B, and 2423A, and she suffered personal injury as a result of such violations. Declaration of Plaintiff Jane Doe, Exhibit A, hereto. Declaration of Tiffany Doe, Exhibit B, hereto. Declaration of Joan Doe, Exhibit C, hereto. Jane Doe, Tiffany Doe, and Joan Doe are each pseudonyms, as each woman wishes anonymity. Tiffany Doe, a witness, was an employee of defendant Epstein, Exhibit B. Joan Doe, a witness, was a childhood classmate of plaintiff who, in 94-95 school year, was told by plaintiff that plaintiff was subject to sexual contact by defendant at parties in New York City during the summer of 94, Exhibit C. Number 8, courts have directed to allow proceeding anonymously where the need for privacy outweighs the public interest in knowing their identity and any prejudice to the defendant. Sealed plaintiff versus sealed defendants. 537F.3D 185, 189, bracket 2D CIR 2008, bracket period. This litigation involves matters that are highly sensitive and of a personal nature, and the identification of the plaintiffs would pose a risk of retaliatory physical harm to her and to others. Exhibit A. All of the 10 factors that the second court articulated are relevant to this analysis, favor anonymity, especially factors 1 through 4, 7, and 10. Bracket e.g. factors 1 and 2, whether the litigation involves matters that are highly sensitive and of a personal nature, and whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or, now we're on page 4, even more critically, to innocent parties, or neutral with respect to anonymity. Protecting plaintiff's anonymity is also appropriate as she is a rape victim. 9. Plaintiff was enticed by promise of money and a modeling career to attend a series of parties with other similarly situated female minors held at New York City residence that was being used by defendant Jeffrey Epstein. At least 4 of the parties were attended by defendant Trump, Exhibits A and B. On information and belief, by this time in 94, defendant Trump had known defendant Epstein for 7 years. New York, 10/28/02. I've known Jeffrey for 15 years. Terrific guy. Trump booms from a speakerphone. He's a lot of fun to be with. It is even said that he likes beautiful women as much as I do, and many of them are on the younger side. No doubt about it. Jeffrey enjoys his social life. And knew the plaintiff was then just 13 years old, Exhibits A and B. I'll get to the comments after this. Number 10. By the way, there's 19 pages and we're at page 4, so this is probably going to be 15. This is probably going to be another half hour. 10. Defendant Trump initiated sexual contact with plaintiff at 4 different parties. On the 4th party and final sexual encounter with defendant Trump tied plaintiff to bed, exposed himself to plaintiff, and proceeded to forcibly rape plaintiff. During the course of this savage sexual attack, plaintiff loudly pleaded with defendant Trump to stop, but with no effect. Defendant Trump responded to plaintiff pleas by violently striking plaintiff in face with open hand and screaming that he would do whatever he wanted. Exhibits A and B. Number 11. Immediately following this rape, defendant Trump threatened plaintiff that were she ever to reveal any of the details of the sexual and physical abuse by her defendant Trump, plaintiff and her family would be physically harmed if not killed. Exhibits A and B. 12. Defendant Epstein had sexual contact with plaintiff at 2 of the parties. The second sexual encounter with defendant Epstein took place after plaintiff had been raped by page 5. Plaintiff had been raped by defendant Trump. Defendant Epstein forced himself upon plaintiff and proceeded to rape her anally and vaginally despite her loud pleas to stop. Defendant Epstein then attempted to strike plaintiff about the head with a closed fist while he angrily screamed at the plaintiff that he, defendant Epstein, rather than defendant Trump, should have been the one who took plaintiff's virginity. But plaintiff finally managed to break away from defendant Epstein, exhibits A and B. 13. Threats of violence against plaintiff and her family continued, this time from defendant Epstein, who, again, reiterated that plaintiff was not to reveal any of the details of the sexual and physical abuse of her, or else, specifically, plaintiff and her family would be seriously physically harmed, if not killed, exhibits A and B. Number 14, while still under threats of physical harm by coming forward and having no reason to believe that the threats had ever been lifted or would ever be lifted, plaintiff, who has suffered from stress, emotional distress, mental pain and suffering, among other problems ever since the assault, was subject to daily painful reminders of the horrific acts of one of the perpetrators, defendant Trump, via mass media coverage of him starting on or about June 16, 2015, over a short period of time, became continuously and unavoidable, exhibit A. Number 15, as a direct and proximate result of the sexual assault and rapes perpetrated by defendant upon her, plaintiff has suffered stress, emotional distress, and mental pain and suffering, as well as adverse physical consequences. As a direct result of the proximate result of the sexual assault and rapes perpetrated by defendant upon her, plaintiff has suffered physical pain and suffering. Page 19. No, I'm sorry, page 6. Number 17. As a direct result and proximate result of sexual assault and rape perpetrated by defendants upon her, plaintiff has been subject to public scorn, hatred, and ridicule, and has suffered threats against her life and physical safety. 18. As a direct result and proximate result of the sexual assault and rapes perpetrated by defendant upon her, plaintiff has incurred special damages, including medical and legal expense. 19. The sexual assault and rapes perpetrated by defendant upon plaintiff were intentional acts. 20. The conduct of the defendants demonstrated willingness, recklessness, and intentional conduct that raises a conscious indifference to the consequences. 21. At the appropriate time in this litigation, plaintiff shall amend her complaint to assert a claim for punitive damages against defendant in order to punish defendant for the actions and to deter defendants from repeating their conduct. 22. Tolling of statute of limitations. Any statute of limitations applicable to rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, false imprisonment of a minor, if any, is told owing to the continuous and active duress imposed upon plaintiff by defendant that effectively robbed plaintiff of her free will to commence legal action until present time. Cullen versus Margotti, 811 F2D 698, 722, bracket 2nd circa 1987, semicolon, Ross versus United States, 574 F, period, SUPP, period, 536, 542, bracket SDNY 1983, period. More particularly, plaintiff was unrelentingly threatened by each defendant that were she to ever reveal any detail of the sexual and physical abuse caused by her by defendants plaintiff, page 7, and her family would be physically harmed if not killed. The duress has not terminated and the fear has not subsided. The duress is an element of the inherent and underlying cause of action complained of herein. The duress and coercion exerted by defendant has been such as to have actually deprived defendant deprived plaintiff of her freedom of will to institute suit earlier in time, and it rose to such a level that the person of reasonable firmness in plaintiff's situation would have been unable to resist. Exhibits A and B. We're still on page 7. Number 23. Both defendant let plaintiff know that each was a very wealthy, powerful man and indicated that they had power, ability, and means to carry out their threats. Indeed, Donald Trump stated that plaintiff shouldn't ever say anything if she didn't want to disappear like Maria, a 12-year-old female that was forced to be involved in a third incident with defendant Trump, and the plaintiff had not seen since that third incident, and that he was capable of having her whole family killed. Exhibits A and B. 24. The duress has prevented plaintiff from starting litigation before this year. However, as soon as she surfaced, she received threats. More specifically, shortly after her first complaint was filed in California, April 26, 2016, she started receiving threatening calls on her cell phone. Exhibit A. Defendants are equitably stopped from arguing that any statute of limitations has not been told, as defendant wrongfully forced plaintiff to refrain from timely commencing of this action by threats, duress, and other misconduct. Exhibits A and B. Zimmerman versus Poly Prep County Day School, Sup 2D 2012, 2012 WL 3683393, General Stencil Inc. versus Chippa 8 New York 2D 125, 126, 1966. A wrongdoer should not be able to take refuge behind the shield of his own wrongdoing. Page 8. I just gotta let you know, this is really hard for me. This is really exhausting. And we're already 22 minutes into it. Most people should be able to read this in 5 minutes. It's taken me forever. Moreover, this action has been brought before the fact given rise to the estoppel have ceased to be operational, i.e., while still under threats of physical harm by coming forward and having no reason to believe that the threats have ever been lifted or would ever be lifted. And since plaintiff has decided to seek redress at this time, plaintiff seeks an order of protection in favor of plaintiff and all associated with her, so as to protect them from harm and harassment from defendants and their agents and associates. Exhibit A. Defamation on information and belief on April 28th, 2016. Defendant Trump provided the following statement to American Media Inc. and on Radar Online LLC for publication on at least their website, radaronline.com, regarding plaintiff's complaint ED CV 16-797-DMG KSX filed in United States District Court for the Central District of California. The allegations are not only categorically false, but disgusting at the highest level and clearly framed to solicit media attention, or perhaps are simply politically motivated. There is absolutely no merit to these allegations, period. The statement provided for publication by defendant Trump was published by said website and has been republished elsewhere in whole or in part numerous times, and similar statements of an attorney for defendant Trump were also published, including on September 22, 2016 by Courthouse News Service. The statements provided for publication by defendant Trump and his agent and that were published by said website are false as they pertain to plaintiff. 28. The published statements are libelous on their face and clearly expose plaintiff to hatred, contempt, ridicule, and Obloquy. That's not a word I'm familiar with. Obloquy. Oh, my vocabulary. Okay. Page 9. 29. As approximate result of the above described publications, plaintiff has suffered loss of her reputation, shame, mortification, and injury to her feelings, all to her damage in an amount to be established by proof at trial. The above described publications were not privileged because they were published by defendant Trump and his agent with malice, hatred, ill will towards plaintiff, and the desire to injure her. As a direct proximate result of defendant Trump's defamation of plaintiff has been subject to public scorn, hatred, and ridicule, and has suffered other injury. Prayer for relief, wherefore plaintiff prays for judgment against defendant and for the following relief. The judgment being entered against defendant for special damages, compensatory damages, and punitive damages in the amount which shall be shown to be reasonable and just by the evidence and in excess of $75,000 exclusive of interest and cost. That all costs of this action be assessed against defendants, including all reasonable attorney fees, costs, and expenses of this action. That the order of protection in favor of plaintiff and all associated with her be issued so as to protect them from harm, harassment from the defendants and their agents and associates, and D, so others and further relief as this court may deem just and proper. Page 10. Jury demands. Plaintiff demands a jury trial of all issue triable by jury in this action, dated September 30th, 2016, respectfully submitted by Thomas Francis Megar, Tom SD New York barcode TM6707. Okay. And then of counsel J. Cheney Mason Law Office in Florida. And then this must be the exhibits. Oh yeah. This I can't really read this to you. I'll show what it looks like though. Well, that actually turned out not to be 19 pages. Thank God. My eyes were going to fall out. I'm not sure how my volume is. I might have had the microphone kind of covered there. Now, from Epstein's brother to somebody else. I don't know who the else is. Oh, I'm so deep. Oh, I